next matter to come before us this morning is Hilliard versus Greathouse. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, wish to reserve any time for rebuttal. If you let me know when you get started, I am keeping track of time. I can keep you apprised of when you're reaching your rebuttal time. But we have read the briefs and we are ready to see who you are.
Thank you. May it please the court, my name is Leslie Gransky, and I'm here representing Heather Hilliard, the mother of Madison and Samantha, in this matter. The core of the issue is that the trial court found there was no change in circumstances because both parties' incomes had changed, and that wasn't sufficient given there had been a previous waiver down to 0. However, there had been a discussion before the magistrate that the father was not exercising standard order parenting time, even though the mother had been ordered and had agreed to drive halfway to permit midweek contact. And he had received the deviation down to a 0 support obligation based on the parties' agreement. The mother wanted to move to 40 minutes away, and the father wanted some relief in support. After that happened, father obtained full-time employment rather than part-time employment, and mother had some increase in her income due to normal residual COLA increases, nothing dramatic. Now, when the parties were in court, the magistrate swore in father when he spoke, but did not swear in mother when she spoke. This was not a matter of counsel presenting statements of counsel, which had become quite a practice in Summit County, and the other attorney presenting statements of counsel where there was no evidence at all. This is really more analogous to the situation where the court forgets to swear people in. They swore in one but not the other. This court has previously recognized that a matter could be remanded for further actions that are taken under oath in Wasilewski versus Jasinski, a 2015 decision cited in the brief. Mr. Greathouse would like us not to have it remanded because there was no evidence taken, but that really is contrary to the spirit of what happened here. The court didn't find that there should not be a revision of support because there was no evidence. It just found that there was no change in circumstances, just general increases of income. Father didn't object to the failure to swear in mother at the court. He didn't object on that basis when he took his objection to the trial court. So that's being heard for the first time now, and it is being used as a weapon to say, oh no, you can't remand this. In fact, if this court finds that there was no evidence heard, then it should remand it, as it did in the Stearns decision, because there was not fully sworn testimony before the court.
Well, if the trial court is ruling on objection, and I'm assuming but have not read the objections that were filed, but assuming that one of the objections was, magistrate, you cannot enter this order because there has not been a change in circumstance, and the trial court says, I find that there has been no change in circumstance. Anything else that happens in the trial court's entry after that, why aren't we done there?
Well, because the trial court didn't address the fact that there is another change in circumstances. The father is not exercising visitation, as was in the agreement at the time his child support was modified to 0. That's another change that the trial court simply ignored.
Right, so that's it. That's evidence or not evidence, depending on who you agree with in terms of a change. But what happened here, correct me if I'm misspeaking, but what happened here is we have the court saying, I don't find a change in circumstance, but then leaving the change as it relates to this tax exemption intact.
I'm very troubled by that,
Okay.
particularly in light of the fact that there's no evidence whatsoever as to how that would benefit the children.
Well,
Yeah.
and does the trial court have the authority to talk about a tax exemption if it finds that this motion that was filed post-decree, I don't find there's any basis, because I don't find there's any change in circumstance? We keep going farther down the road, I'm trying to figure out where it ends.
I understand what you're saying, and in honesty, the statute says that if you consider child support, you can consider the exceptions. So, on that basis alone, that's not why she should prevail on the exemption. I believe the court could consider that. I think it did so improperly because the mother's consent to let father claim one child was based on the context of, we're going to finally get some child support going here. Every time he had needed an accommodation, she had come through with it. She was finally asking for some child support when he finally obtained some full-time employment. And in exchange, she was willing to say, okay, you claim a child. She had been bearing all of the medical expenses and has to finish out that tax year. And then, yeah, dad should start paying child support beginning that year, and he should have an exemption. She didn't object to that finding in the magistrate's decision because she didn't agree to the totality. Didn't disagree with the totality of the magistrate's decision. He pays some child support, he gets some exemption. That was a good decision. That's why she didn't object. But the important thing is, there was no evidence whatsoever presented as to how the children would benefit by allocating the exemption to the father. In fact, there was no evidence on that topic at all. It was just a gracious action by the mother saying, I'd like some direct money support, and in exchange, you should benefit from the tax exemption. So now we're in really the untenable and inequitable position that father's asking that he have an exemption when he hasn't presented any evidence, as the non-residential parent has the burden to do, as to how it would benefit the children, and then he's not paying child support as well. So it's not even an even deal, it's taking money from the children, because it's pretty clear that the home in which the children reside, having more money is going to benefit children more than the house where they spend some time occasionally. The burden is on the non-residential parent to show this. There is no evidence whatsoever how it would benefit the children in light of the lack of a child support order. So we would ask that this court send this back, and we can do this all on evidence, and we can honor the Stearns decision, and we could do the right thing for these children. Thank you.
Good morning. I'm Susan Pritchard for the appellee Greathouse. I think we have to focus in on what the assignment of error is here. And the cases that have been cited are actually the reverse of the situation we have here. If my client had lost in the trial court on the basis of the record that this court has before it, then a remand would be appropriate. Because let's say instead of the court correcting the magistrate to a zero support order, that the judge had left it at the, whatever it was, $400 or $500 a month in child support. And my client's appealing. Oh yes, he has a valid right to say, wait a minute, there were no tax returns, there were no exhibits, you didn't follow the local rule on exchange of evidence, mother was never sworn, mother didn't testify. You didn't address the 4 issues that were cited when you deviated to zero. You know, the original order that brought them down to zero cited 4 bases for determining that huge deviation, really, and it wasn't a percentage, it was a complete deviation to zero. Nothing is on the record from mother, but she never testified. So the only thing we have is her counsel. So my client would certainly have the right to say, we need to remand this and take testimony, because mother didn't carry her burden of proof. We have the flip of that in this case, where mother, who had the burden of proof, regardless of what she's saying about the tax exemption now, was her motion. And I don't know why she brought the motion on tax exemptions, but she did, in addition to her motion to add child support after it had only been a year since they agreed there would be none. She has the burden of proof. She has the complete burden of proof on that child support issue. So what she needed to do was to address those issues, which included based on the agreed entry, the allocation of parental rights, she never says, well, okay, this is the way it was when we agreed and this is the way it is today, nothing. No evidence regarding the children's physical living conditions, that was the second basis given, nothing. There's no discussion, it never comes up. No evidence of change regarding in-kind contributions made by either parent. There's just, the record is completely devoid of any evidence from her about those, which would, you know, in order to have a change of circumstance, you first have to establish what's going on. What was going on at the time that the motion or the agreed entry went on, and what is it today? Has there been a change, and is it a substantial change? That never occurs. So what she's saying now is, well, I didn't do it, but I should be given a second opportunity. Well, why? You know, that is absolutely against my client's rights. He was there at the hearing, pro se as it was, but she had the opportunity at that point to present whatever evidence she wanted to present, and she didn't do it. Even in the brief, when you look at the only thing that they raise is the parenting time issue. That's it. They can't point to anything else because there isn't anything else. And the only statement about that, there's really two. One is from counsel when he says early on, that has never been exercised. And we don't know what that even is. He's talking about the standard order of companionship or parenting time, but that's it. Okay, so that's a statement from him. And later on in the transcript, mother says something about, I have the kids 75% of the time. Well, that's about right. The order was that dad would have every other weekend and a day during the week to be determined by the parties. It's kind of loosey-goosey on that. But if she has the kids 75% of the time in an unsworn statement, which is not evidence, obviously, that's what was going on at the time the agreed entry of 0 went on. So, no difference. So, their assignment of error is that the court made a mistake, the trial court now, in overruling the magistrate's decision on unrebutted evidence. Well, there's no evidence, so that's not even accurate to say that. That father was not exercising his parenting time. So, on the basis of what mother presented, the trial court came to absolutely the right conclusion, that there had been no change of circumstance. Now, incidentally, the court does discuss income, but of interest is that my client's income is actually down. There is a child support worksheet that's attached to the agreed entry that went on in 2014, which was the last entry before this all started happening. And they have him at about $35,000 and mother at about $44,000. At the time that the hearing comes up, my client's income is actually down to about $31,000 according to the findings of fact, and mother's is up. Now that would militate in the reverse, and in other words, mother paying father child support. And this is an area of the law that, to my understanding, has never been developed. I find no case law that addresses this, but we have a shared parenting plan. Now, the magistrate erroneously says in the transcript, you're the residential parent talking to mother. That is not true. They have a shared parenting plan. The parenting time schedule was modified by agreement, and mother was named the residential parent for school purposes, which is required by statute. That's it. And okay, it's true that the parenting time schedule is that dad has every other weekend and a day during the week, maybe 2 days, depending on how you read that agreement and what they end up doing. But who pays who child support? You know, mother's making $20,000 more than dad, and we have a shared parenting plan. The statute doesn't say that you go by the parenting time schedule necessarily. You look at incomes and other factors. So anyway, I'm digressing a little bit, but I do think it would be possible in this scenario for mother to be paying father child support. Certainly it makes no sense to impoverish dad and tell him to pay child support to a mother who's now making even more money than she was at the time that the parties agreed there would be none. The remedy was simple, and this is what went wrong on the trial court level in my opinion. When father filed an objection to the magistrate's decision, they had 10 days. After I filed the objection for dad, they had 10 days. That was a crucial 10 days. They had the opportunity to make a decision. Do we want to cross appeal? Now, they like the decision from the magistrate. They don't know what the court's going to do necessarily, but the case law out of Summit County, especially this judge, and your case law, but also his decisions as judge, has been consistent that I've seen, that if there's an agreement to the parties, by the parties on child support, unless you've got some change of circumstance, we're not just changing the amount of child support. So they would know that too, or have access to that information as well. During that 10 days, they have to say, well, what might happen here? The judge, do I need to object and say, by the way, that agreement that we made on the record, and there are 3 or 4 places in the record where mother does say, again, unsworn testimony, but where or unsworn statements, where she's saying, oh, if I can just get the exemption for 2015, he can have the exemption for 2016. The majority of the conversation in this transcript is about health insurance. So if you just go by weight, what these people, at least mother, seemed to have been concerned about at that point was making sure that dad got those kids covered on his health insurance now that he's full-time for the city of Akron, waited his 90 days and can get health insurance because it's really cheap and it's really good. Okay, so he's going to do that. They never actually figure out how much it costs. There's no documents presented that tell you how much the out-of-pocket cost is for these kids. None of that. It's all just this big kind of wide-ranging discussion. My client's being cross-examined sometimes by misses, so it's all very bizarre. But that's where they spend the majority of their time, is talking about health insurance. But she does say he can have the exemption. So mother needed to file an objection in that 10-day window and say, okay, I understand, Your Honor, you're going to be considering what the magistrate did. If you're thinking about reducing the amount of support, my agreement to that tax dependency exemption was contingent. And I revoke it, or I didn't mean it, or just point out that it was contingent. If it was, and you can certainly read that transcript to say clearly that mom was okay, if I get 2015, he can have one of the kids for 2016. So she didn't do that. When she didn't file her objection, she waived it. I don't think she has any right at this point to be addressing the tax dependency exemption because she had an opportunity to raise it in the trial court where it could have been rectified, and she chose not to. So it's true, counsel is correct, that what I'm asking on behalf of my client is that you just overrule her assignments of error. Look at what she's saying. She doesn't even ever really address the issue of change of circumstance, but that's what she means. The court found no change of circumstance. There was no change of circumstance. The judge was correct in his decision. His decision needs to be upheld. Thank you.
We would ask that the court do equity in this case in the best interest of Samantha and Madison. They have been denied the right to child support from their father based on an agreement. And then father doesn't do what he agreed to do under that agreement, which is to visit them under the standard order. And mom agrees to drive halfway from her home, which is about 20 minutes each way, in order to facilitate that. But he doesn't do that. He doesn't do the standard order. And mother says, on the record, I have 75% of the time. If you look at the standard order in Summit County, that's about 66% of the time for the parent where the children live. Actually, it's a little bit less because during the summer there would be times, but I'm just taking that out, just doing alternate weekends. There's a significant increase when he doesn't use the standard order, and if this court would like to send it back so we can take that to minutia, I think it would be appropriate. However, it's hard to believe that the tax exemptions for one of the children should be allocated to father who does not visit under the standard order and does not contribute in any way to the children's support. The only place where those tax exemptions benefit the children is if they're granted to mother. Thank you so much.
What would you say about the waiver argument?
It's hard for me to think that she waived that argument where it was part of a package deal. She was looking at the entire judgment, the magistrate's decision that was issued, and she didn't object to the decision, so she didn't file an objection to the decision. It wasn't erroneous until child support was taken away.
As to the dependent, as to the exemption though.
I'm sorry.
I can understand that as to the child support, because he's picking up child support.
If you were doing that, yeah, she would give it.
But what about the second issue as to the exemption?
I believe that the mother was looking at the package, and that's why she did not.
Okay, thank you.
Check. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which you can access through the 9th District Court of Appeals website. Thank you.
Thank you very much.